Hello, my name is Ashley Barang, and I'm pleased to welcome you to our latest ITInsights virtual briefing on the EU-U.S. data privacy framework. Last Friday, the Biden administration unveiled a new executive order that details the roadmap for the U.S. to follow to implement that framework. The movement of data across borders is foundational to global trade and innovation in our increasingly digitized world. As the premier advocate for the global technology industry, ITI called on the US and EU policymakers to reach an agreement that allows businesses to share data across the Atlantic. Today, two of the industry's foremost policy experts, ITI's Guido Lebrano and John Miller, will share how these actions will help to restore business certainty and create continuity of key business operations, while also upholding European citizens' fundamental rights and the security and public safety interests of the US, EU, and others. John and Guido will share their analysis of the new EO, related Department of Justice regulations, and their legal elements. They will also explore how this new framework can help to stabilize future data flows between the US and EU, and examine how this proposal will be viewed by key stakeholders in Europe. We hope you will join today's conversation by adding your questions to the chat. We will turn to your questions later in the hour. Demonstrating ITI's unique global footprint and advocacy, I am pleased to introduce one of our speakers. Guido Lebrano is ITI's Senior Vice President of Policy and Director General for Europe. Guido, thanks for joining us for Brussels.
Hi, Ashley. Thank you very much. And good afternoon and good morning to all of you. Let me also introduce our colleague, John Miller. John is ITI's Senior Vice President of Policy and General Counsel. John is based in Washington, D.C. Good morning, John.
Good morning, Guido, and thanks, Ashley, as well.
So Ashley has briefly introduced the topic of this second edition of our ITI's live briefings. Let me very briefly set the scene here, and then what I'll do is I'll turn to John for an initial overview of what we've seen coming out of the White House last week. So last Friday, as you probably many of you have seen, US President Biden signed an executive order on enhancing safeguards for United States signals intelligence activities. This executive order articulates the steps that the US is taking to implement the new EU-U.S. data privacy framework agreement that was announced by President Biden and European Commission President Ursula von der Leyen in March 2022. So this EO, together with also the DOJ, Department of Justice regulations that have been signed by the US Attorney General, are aimed to help stabilize transatlantic data flows following the annulment of the Privacy Shield framework in 2020 by the European Court of Justice with the Schrems II ruling. Now, the European Commission will now need to look at what has been adopted by the US government and then adopt a so-called adequacy decision under the GDPR to make the data privacy framework program operational. And we'll go into more of these details through this webinar. So let me remind you that the webinar is recorded, and also that all of you from the audience are welcome and actually encouraged to come up with any questions you might have through the chat function in Zoom. So this being said, if okay, John, I would turn to you for an initial overview, and maybe you can explain us, first of all, the interplay between the executive order and the DOJ regulations and what each of them does in a few minutes, and then we'll go a little bit deeper.
Sure, Guido. Happy to do that, and again, welcome everyone. Thanks for joining. I mean, just to take a quick step back, and to kind of reiterate something that you mentioned. The negotiators here needed to craft a solution that was consistent with EU law, including the EU Constitution, or Charter, and addressing, of course, the Court of Justice precedent in Schrems II, and other cases, and also the solution here did have to be consistent with U.S. constitutional law and protections as well, including relevant U.S. Supreme Court precedent here. And that's important because it was really a delicate balancing act that they needed to execute here in trying to create a solution that was faithful to both constitutional systems. So, I think it's important when we talk about what an executive order and the Department of Justice regulations are. As you mentioned, Friday marked the implementation of the political agreement that was, from back in March by the U.S. But also, very importantly, it marked a change in U.S. law. I mean, the executive order issued Friday has the force of law, as do the Department of Justice regulations. So, I just wanted to point that out because it's much different than, for instance, back, in the Privacy Shield context back in 2016, where we had kind of letters at annex, which is a very different type of thing than what we're talking about here. We're talking about legal changes. With respect to the executive order, an executive order, it's an order by the president here, but it does have the force of law, and it commands, in this case, in large part, the intelligence community of the United States to do certain things, to institute certain safeguards regarding U.S. surveillance activity, and specifically what's known as signals intelligence activity involving Europeans and other non-U.S. persons. As we can get into in a minute, they've of course tried to do that in a way that is necessary and proportionate to meet the Court of Justice's essential equivalence test in that regard. It also creates transparency into the use of the EU personal data by U.S. authorities and articulates the national security justifications behind it. It also creates the second part of the executive order, and this is where the Department of Justice regulations also come into play. It creates a mechanism for individuals from the EU, as well as from other qualifying states or economic regions, to seek review and redress if they feel their personal data was used in violation of these established safeguards and other privacy protections. Again, the executive order lays out the authority for what's known, at least in this context, as a two-layer redress system. We can get more into that. But the second layer of that system establishes a data protection review court, and the Department of Justice regulations are, critical to providing the implementation details of how that court is set up, and importantly, for instance, where the judges come from, and a bunch of other details that I know we'll get into in a minute. And something else that's important is that the Department of Justice regulations, at least in the way that they are set up, are, there's also an element of independence, of course, from the president, which is very key in this context as well. A couple of other things that I did just want to note before we, move on to maybe some more of the details. The executive order and the Department of Justice regulations, as I mentioned, they signify changes in U.S. law that, many of which took place immediately. Those, there are certain things that do need to be implemented, but in terms of both the law and certainly of the policy expressed therein, those new laws and policies do and can have an immediate impact. And I guess I wanted, from a policy standpoint, I wanted to note also that the executive order articulates a dual purpose to the executive order that I hope will resonate with you and our other attendees from Europe, Guido. Number one, one of the goals of this executive order, and I think it's probably worth mentioning what the name of the executive order is, right? It's an executive order on enhancing safeguards for United States signals intelligence activities. But the policy expressed therein is not just to protect U.S. national security, but to protect the security of the United States allies and partners. You know, I think this is an important thing to note because I think we've all seen over the past, several months how important that notion of allies and partners is, particularly in the context of the Ukraine conflict. And the second thing that it notes, the other of those dual purposes is that all persons, regardless of nationality or citizenship, have legitimate privacy interests in the handling of their personal information, and that the United States government will treat all those such persons with dignity and respect in the context of surveillance and signals intelligence activities and the various safeguards that are set up here. So, I certainly think that's very significant in the European context. And, it's also potentially significant beyond that, which we can get into a little bit because it's not just European citizens who might be able to avail themselves of the protections in the redress mechanism, for instance. Thanks, Guido.
Thanks, John. I mean, there's clearly a lot to unpack there, and all of these elements are very important in the context of the future process that now the European Union will start and is starting. Maybe to go back to a couple of the points that you've mentioned, and the fact that this executive order is specifically on enhancing safeguards. So can we talk a little bit more about that? Can you describe more in detail the safeguards that the executive order is introducing for U.S. intelligence activities, in particular as regards the respect of the necessity and proportionality principles that are emphasized by the European Court of Justice in the Schrems ruling?
Yes, absolutely. Again, just to provide a little bit of context for folks, because I think it's important here. If we go back to 2013 timeframe, and folks might remember, actually in 2014, President Obama had issued what is known as a Presidential Policy Directive, PPD 28, which back then had established some safeguards and arguably established new international norms around foreign intelligence collection. And that was a very much a kind of a landmark document at its time. And so it's important to note that the new executive order builds on PPD 28 by articulating clearer and more detailed protections for people outside of the United States. And as you mentioned, I mean, it really almost seems like a kind of a painstakingly thought out response to the European Court of Justice decision in Schrems and its other jurisprudence on government access. But again, as I mentioned at the outset, tailored to American law, presidential power, constitutional law here. So in terms of what the executive order is doing, one, it's requiring U.S. intelligence authorities to limit signals intelligence activities to what is necessary and proportionate. Those terms might sound vague and ambiguous, but number one, they haven't been expressed in U.S. policy previously, and number two, they're very significant in the context of Europe and the Court of Justice. The other thing that I wanted to mention was that exactly how these necessity and proportionality provisions and safeguards work, right? I mean, so first, there are explicit mandates on the surveillance collection, and processing activities. And the EO structure explains what the limits are. Then it, talks about, what they mean, and then it also provides some additional oversight mechanisms. I mean, I actually think that for purposes of this section, it's very important to even read it's short, but I do want to just read the two paragraphs that kind of lay this out in terms of the necessity and proportionalities piece. It's section 2A, 1A. For those who are referring to the EO at home, but it says that signals intelligence activities shall be conducted only following a determination based on reasonable assessment of all relevant factors, that the activities are necessary to advance a validated intelligence priority, although signals intelligence does not have to be the sole means available or used for advancing that validated intelligence priority. And then critically that signals intelligence activities shall be conducted only to the extent and in a manner that is proportionate to the validated intelligence priority for which they have been authorized, with the aim of achieving a proper balance between the importance of the validated intelligence priority and the impact on privacy and civil liberties of all persons, regardless of their nationality or wherever they might reside. So they're placing explicit guardrails around the permissible collection activities. They also articulate some impermissible ones. I'm not going to read through all of those different justifications that are spelled out. But the safeguards address what signals intelligence can be collected, how it can be used and shared, and how long it can be maintained. Amongst other things, there's also a list of various legitimate objectives, that you might expect to find in something like this. It also prohibits other objectives, and it prescribes oversight mechanisms, including reviews by the Civil Liberties Protection Officer of ODNI. But also the Privacy and Civil Liberties Oversight Board as well. So I will stop there, I think. Although you might have follow-up questions on some of that, and I'm happy to expand.
Thanks, John. So I think we probably want to go a little bit more in detail on the oversight and the redress system. But I've seen that there's already a couple of questions that have come through the Q&A function. So if you agree, maybe we can look at these questions first, and then which are more referring to the broader system in which the EO comes in, and then we go back to the specifics of the redress and oversight. So there is a question on the meaning of this executive order and also the safeguards that it contains for other countries outside of the European Union. The question from Rini Patel specifically refers to Asia, for instance. I think you referred earlier that this is not only about the European Union. So can you explain what is the broader effect of this geographically?
Yeah, sure. And I mean, I think there's, there are a couple of different dimensions to that answer. As I said at the outset, the executive order itself is not specific to Europe, even though clearly, as we mentioned, the implementation of that political agreement was driving the development of this executive order, the political agreement, I should say, between the EU and the U.S. announced in March. But the executive order itself enhances safeguards for United States signals intelligence activities for everyone. Number one, I mean, and I guess I would break it into two pieces. I mean, the restriction, at least as I'm reading it, I mean, the what we just talked about and the safeguards and limitations on to address the necessity and proportionality dimension of U.S. surveillance activities, that exists now in law, and in theory, applies across the board. There is a separate part of the executive order that is specific to redress, and specifically this notion of qualifying states, and that has a couple of different pieces, and I think it's worth unpacking this because I don't know that there's been a lot of focus on it. So I mean, to implement this redress mechanism, and it's a two-layer mechanism, as we mentioned, including access to this data protection review court that's being established by the DOJ regulations. The Attorney General of the United States is authorized to and expected to designate countries or regional economic integration organizations, and that's clearly a reference to the European Union, as what's called a qualifying state for purposes of the redress mechanism. I don't know if the Attorney General has designated any states yet, but we certainly would expect that the European Union would be so designated. Two other countries that I know in a briefing were mentioned as likely, certainly on the short list, given history, is both the United Kingdom, as well as Switzerland. I mean, there, in addition to the EU-U.S. privacy shield, there was also a Swiss EU-U.S. a Swiss-U.S. privacy shield there. And in the context of the UK, there are ongoing negotiations over adequacy there between the U.S. and the UK. But the structure that's set up could apply to any countries, as long as they meet a couple of different criteria. Number one, the laws of the country need to require appropriate safeguards in the conduct of signals intelligence activities for United States personal information that is transferred from the U.S. to the territory of those countries. So, in a way, this is, you could think of this as a reciprocity position. I mean, the U.S. is not going to grant the access to this redress mechanisms or qualify a state that does not offer similar protections to U.S. citizens. And then, secondly, the second qualification is that there's an expectation that those countries who qualify will permit or are anticipated to permit the transfer of personal information for commercial purposes between the territory of that country and those member countries and the territory of the United States. So this is very significant in the context of cross-border data flows, obviously. And then there's a third criteria as well, is that the designation will advance the national interests of the United States. That is not further explained, however, but hopefully that was helpful.
It was helpful. And so I think, if I can try to sum it up, basically there is an element of necessity and proportionality that is now part of the US legal system that applies in the US regardless of any external dimension. It applies to US surveillance activities. And then there is an external, let's say, element, which is redress and access to the data protection review court that would apply to those qualifying entities that could be countries or regions like the whole of the European Union under certain conditions of reciprocity that you just explained. There is another question in the chat that I wanted to address, and again, really, we invite everyone who has questions, comments to jump in and ask the question. We are very happy to address them. So the question is for John. So given that the EO can be revoked, is there worry that the provisions in this transatlantic privacy agreement might vanish under future administrations? And if yes, the question reads, is ITI pushing for legislative bills that codifies the US side of these privacy standards as well? So we've addressed the sort of geographic scope of this. Now, what happens over time?
Yeah, thanks for that question. And certainly over the past couple of years, there's been a lot of discussion on whether, legislation is better or whether executive order is better, or, what the differences might be. I mean, so, well, first to directly address the question of whether there's a concern that the agreement, that the executive order would be revoked. I do not have a concern that it would be revoked for a couple of reasons, even though theoretically it could be revoked. I mean, the entire reason that the U.S. Government has and President Biden has signed this executive order, it's clearly in the U.S. national interests. I think it's notable that under the previous administration, which was of course a different administration under President Trump, a Republican administration, the negotiations with the European Union to do something like this had started back then, and so it's certainly kind of a bipartisan set of interests that are implicated here. Again, I think those interests that I articulated at the outset and that are articulated in the executive order, protecting the national security of the U.S. And its allies and partners, and also protecting the privacy and civil liberties of all citizens, no matter where they reside, and establishing safeguards for that. I mean, I think that those are those are not interests that are likely to vary, between administrations. And secondly, I mean, clearly, there is a purpose behind this, which is economic. And I think certainly the U.S. government, as well as the European Union, perceive it in their national interests to maintain data flows between the U.S. and Europe, and to maintain transatlantic data flows. I forget the exact number of billions of dollars, but I think the transatlantic economic relationship is, I don't know, at least 7 or 8 billion, and it's underpinned by data flows. So it just seems, it's hard to imagine a scenario where a president would revoke this type of executive order. Secondly, executive orders. I mean, perhaps this is a bit of irony, underlying this question, but, executive orders typically don't get revoked from administration to administration in the United States. I mean, one of the executive orders that is central in the decision of the Court of Justice of the European Union, Executive Order 12333, has, that dates back to the 1980s. I mean, so that actually is older, if you will, than much older, for instance, than the GDPR, right, which replaced the predecessor data protection regulation. So, I mean, if you really think about it, there's just, I would say there's an equal likelihood of a law being updated or changed or revoked as there is of an executive action being updated or revoked. The one other thing that I think is really important here is, and this is, I know that there's been some good academic writing on this topic and other issues, but it's not necessarily the case that a piece of legislation could actually address those U.S. constitutional issues that I raised earlier, and that I suggested also establish some of the parameters of what could be agreed to here. In particular, due to the way that the U.S. court system functions under the Constitution, access to what are known as Article 3 courts is conditioned on what is known as standing in the U.S. system. Standing requires an injury in fact, and it would be very difficult, if not impossible, to establish injury in fact to all global citizens in all cases under the current line of U.S. Supreme Court laws there. And so I should say U.S. Supreme Court cases such as the Ramirez case, for instance. And so, this mechanism and can provide that access to the Data Protection Review Court without having to get into those very difficult issues of standing here. So, I mean, those are just some reasons why I don't think it's likely that this will be revoked. I'm not too worried about it. Oh, there was one other piece of the question. Are we supporting the codification of this in law? I note that some commentators have already mentioned that could happen. It certainly is not precluded, I don't think, to codify this in law. It's probably early to be calling for that, since it's been out a few days, and I think we at least want to be certain that this successfully provides the basis for the adequacy decision first. But I mean, that's always something that I think is on the table to codify an executive order or an executive action.
Another element of the sort of the temporary dimension of this is that, of course, as you mentioned, the primary reason why this whole process was started was to comply with the requirements of European Union law to allow for data transfers between Europe and the United States. And so that is something that is disciplined by the European General Data Protection Regulation. We will discuss in a few minutes how the European process will go through with the adoption of an adequacy decision. There is a requirement in the GDPR that the adequacy decision, there is a review clause. So basically, after a certain amount of time, which is a maximum of 4 years, there will be a compulsory review of the legal system of the third country, so the United States in this case. So if a change like that would happen, that would basically wipe out these changes in the US legal system, then that review would capture that change. So that would make the whole situation very difficult again. So then the US is, of course, very, very well conscious of that. So that would be another element eventually to that part.
Yeah, I mean, that's a really important point too, Guido. I mean, obviously we have not seen the draft adequacy decision is not ready yet. Presumably, I think it's going to be at least a few more weeks as we understand it. But yeah, I would also, in addition to those annual reviews and that review mechanism, I would imagine that maintaining adequacy will be conditioned on these legal changes being maintained. So it would be against the a future US president's self-interests to revoke this executive order, in my view.
So there is another question, John. I think broadly, everybody's wondering, what is the impact of this on business? What is the immediate effect of the executive order? And also what happens to pending proceedings by national DPA, Data Protection Authority? I think that's also, an interesting element in this transition. And the specific question from someone in the audience is not only what the implication of this order is for companies, but specifically when these companies are processing personal data of European citizens, but then the data is sitting on US systems.
Yeah, thanks. I mean, a couple of things. As I mentioned at the outset, these legal changes are now on the books in the US. I mean, certainly from the perspective of the necessity and proportionality safeguards, US law changed last Friday, and there are now very tangible restrictions on what the US government can do or can't do with the data of foreign citizens, no matter where that data is, frankly. I mean, whether it's in Europe or back on servers in Silicon Valley or wherever. And so I think one immediate impact is that look, if I were a lawyer for a company, a privacy lawyer, and I was working on a data transfer impact assessment, as of course required by after Schrems, given the new standard contractual clauses and the EDPB guidance, I think previously companies were citing things like PPD 28 and some of some of those other protections that had been developed over time but had not been codified, such as those that were reflected in that September 2020 memo by the Department of Commerce, ODNI, and the Department of Justice. Now those protections have been codified in law via this executive order and those limitations on necessity and proportionality. So I think companies immediately are in a better place, and they can refer to those things, today. I think, it is true on the redress side that the court is not fully functioning and up and running yet, but it's notable that the executive order gave the Attorney General 60 days to issue the DOJ regulations. They were issued in about 2 hours, I believe. So clearly they had been working on those already. But my sense of it, and what I would anticipate is that they are going to have do everything they can, the U.S. government, to get that redress mechanism up and fully functioning, as quickly as possible. So even though the redress mechanism exists on paper right now, it'll be, probably could still be referred to. It'll be up and running soon, I would anticipate. I think the rest of the question, let me just make sure I'm answering it entirely. Was there something else about just the location of data? Yeah,
yes. So the question was referring to how data, of EU citizens would be stored on US soil, essentially.
Yeah, the adequacy decision that we, certainly hope will be issued soon, and that we will advocate should be ratified by other key EU decision makers, will address, transfers to the United States. I don't think it should matter if the data is, if data is being transferred to the US, the clear implication is it's perhaps also going to be stored there. I think the protections that are offered in this executive order and the Department of Justice regulations are designed to certainly be able to support an adequacy decision, and it would be the same answer as with any adequacy decision, that the European Commission maintains with whether it's with Japan or Korea or the United States. So I don't think there's not going to be any difference between this adequacy decision in practical terms and in practical impacts than any other adequacy decision under the GDPR.
So there's a few more questions, but we are starting to talk more and more about the adequacy decision. So I'd like to take a moment and maybe summarize what's going to happen next on the European side. And so, as we mentioned, this is regulated under the GDPR, which allows for personal transfers of data of European citizens to third countries outside the European Union on the basis of an adequacy decision. Now, an adequacy decision, in essence, is when the Commission assesses the level of protection offered by a third country to personal data of European citizens. And so, based on this assessment, it can adopt a decision called adequacy, where it verifies if the safeguards, in this case, with the United States, it will verify if the safeguards and the framework that is being created by the executive order and the DOJ regulations are sufficient. As you hinted earlier, I think there is a major difference now, which is compared to the Privacy Shield, which is the last ruling that annulled the Privacy Shield, contained a very clear set of requirements based on an assessment of the US legal system that pointed to necessity and proportionality requirements, as well as the importance of the independence of the Data Protection Review Court as regards redress. So this draft adequacy decision is largely expected to be presented by the European Commission in the next 4 to 6 weeks. So that would lead us roughly to the middle of November or the first half of November. And then this document is subject to the so-called comitology procedure, which is where a committee composed of member states representatives would look at the Commission draft adequacy and deliver an opinion by qualified majority, which means roughly at least 15 member states that represent 2/3 of the European population need to support the European Commission draft adequacy decision. Through this process, also, it's important to mention that not only the Council, but also the European Parliament have a so-called right of scrutiny, and the European Parliament is largely expected to issue an opinion that clearly carries a certain political weight on the adequacy decision. And finally, there is also a requirement in the GDPR that the European Data Protection Board, which is the body that puts together the national data protection authorities, also provides an opinion on the draft adequacy assessment. So this whole process is expected to take roughly 6 months, which means that the adequacy decision will likely be officially adopted somewhere in the spring of next year, March, April. And at this point, then the data transfer framework will be operational. So there's a number of steps in between. And I wanted to mention this because there's also a question about what EU countries will support this new data transfer versus oppose it. So of course, this is, it's difficult to say, but what I can say, I think, is that there is a general, very clear awareness of the importance of this mechanism. And I think insofar as, the assessment shows how this executive order and the DOJ regulations are actually taking significant steps to address the concerns raised by the Court of Justice. Those, I think, member states who do not have like political, let's say, opposition to moving forward with the new framework. And I think there is also, I think there's a couple of other questions. One, from me, John, to you on maybe if you can in a couple of minutes describe specifically the third requirement in the Schrems II ruling was independence of the court. Can you tell us a little bit more about that aspect of the new review court that has been established, that is going to be established?
Yeah, absolutely. And it's, just, if we can boil down, the first part of the EO to two words, and what's important, it's necessary and proportionate. And if we can boil down what's important about the redress solution and the new mechanism that's been created here, again, pursuant to what the court's requiring, it's that it's independent. Is that the new redress mechanism, this new court is invested with independent and binding authority. So it's really those two things, both independent and binding. There is, as mentioned, there's a two-layer redress mechanism. The first layer does deal with lodging a complaint with the Civil Liberties Protection Officer of the U.S. intelligence community, and there's kind of a fact-finding purpose there. But the second layer, and it's important to note that access to this second layer can occur as a matter of right, is the establishment of this new data protection review court. A few different ways, and establishing this court as independent has clearly been a key since the Schrems II decision, for sure. It's independent in a few different ways. The court is composed of judges, most likely. This hasn't happened yet, the designation of these judges, but they cannot be chosen from inside the U.S. government, so they are outside judges. They're appointed based on specific qualifications, specifically around expertise in both privacy and national security, and really importantly, they can't be dismissed, other than for something really egregious like committing a crime, for instance, or something like that. And that's really important, and it's really important to, I think, compare that structure and that independence to the ombudsperson mechanism, because the ombudsperson was not only a government employee, for instance, at the State Department, but it was a political appointee. So certainly very difficult to describe as independent. In any way, and then the other thing about it, and this is what the executive order is very important in commanding that these decisions are binding, but neither the Attorney General nor the President nor any of the intelligence agencies or anyone else can kind of avoid the results of the rulings made by this data protection review court. The executive order says this, these decisions are binding. One of the things that, the executive order typically does is that the president has the authority to command other parts of the government to do or not do things. And here, he is saying you must adhere to the decisions of this court. The one thing the president cannot do, however, is then say, "Oh, I'm undoing the creation of this court," or I can interfere with it. And there is existing U.S. Supreme Court precedent that for instance, involving our independent counsel statute, where there's a similar structure where regulations are promulgated by the DOJ or another agency, and those and they must be adhered to. So I think here we have both independence and we have binding authority, and so I certainly and the negotiators designed it this way, right? Because they are trying to adhere to what the court is requiring.
Thanks, John. And that actually leads us to another question in the chat from Alexandre from Le Monde. Alexandre is asking, are you confident it won't be cancelled by the European Court of Justice in a Schrems II decision? So first of all, I mean, I'm fairly confident there will be a challenge in court, and that's fine. I mean, that's what courts are for. And from a business perspective, I think what matters the most is really that we have a stable system, and so having a ruling one way or the other gives you this type of stability. I think this is an assessment that takes a fairly long time. I mean, I'd like to give an answer now, but we've seen it for 3 days, and so I think it would be. We clearly need to look into this. I think what this discussion is also showing is that there has been a lot of elements put into this. In the independence of the review court, all the requirements to ensure that surveillance activities are necessary and they are proportionate. I mean, all of this is really geared towards a framework that provides as many safeguards as possible. And this is clearly what the European Court of Justice will look at. What do you think, John?
Yeah, I mean, I certainly agree with you, and I think in the sense that it will be challenged. I think Mr. Schrems has already indicated he plans to challenge the new system and the adequacy decision. I assume once it is published. So no surprise there. I mean, it's always look, it's always difficult to predict what a court will or won't do, right? But I mean, one of the reasons for optimism here is that, as Guido mentioned, for over the past 2 years, the U.S. and EU negotiators and their teams of lawyers have been doing everything they can to address what the concerns that were articulated by the Court of Justice in the Schrems II judgment. I mean, I think it's notable, that the Commission put out an FAQ document on Friday, where they noted that. I mean, certainly, I would assume the negotiators would still be negotiating if they did not think they had found the solution yet. So I think that's reason for optimism. Based on our initial analysis, I mean, all along, I think over the last 2 years, folks have been saying that the redress challenge was the thornier challenge in these negotiations, and the redress challenge, there is some really top-rate scholarship out there that goes over why this type of solution does pass muster under both the EU and U.S. constitutions, and it has been unrebutted for several months. I mean, so I think there's lots of things we can look to that give us confidence. Ultimately, I think we want to, study the agreement a little bit more. But sitting here today, there's certainly reason to be optimism, and certainly, one thing's for sure: we know this is has a much better chance, I think, of survival than the Privacy Shield agreement. because it is addressing these issues these key issues of essential equivalence in the court's analysis, necessity and proportionality, and with respect to redress, making sure it's independent and binding authority.
Thanks, John. I'm still looking at the questions. There's a few more. It's great that this shows there's so much interest around this issue. There's a question about what you referred to earlier, the reciprocity requirement in the context of redress. So how does that work? Will the US lead a process similar to the adequacy assessment that the European Union does? Do we already know how that would work?
That is a good question. I mean, for those interested, this appears right near the end of the executive order. I mean, it is certainly not as, at least based on what this seems to articulate, it does not appear to be nearly as cumbersome, if you will, of a process as the comitology process in Europe for approving an adequacy decision, in the sense that this seems to vest the Attorney General with the authority to designate countries based on those three factors, the laws of the country, and whether they're also providing appropriate safeguards that are similar with respect to signals intelligence activities on U.S. persons, whether there's an ability to transfer personal information for commercial purposes out of the country to the United States, and whether the designation would advance the interests of the United States. I mean, the only other thing I anticipate it can be done relatively, it's not a bureaucratic process, I guess is what I'm trying to say. It actually seems somewhat similar to the process that exists under the what folks may be aware of, the Cloud Act, where the Attorney General is designating countries that are eligible to sign Cloud Act agreements based on again meeting a set of criteria. Notably, the U.S.-UK Cloud Act agreement went into effect last week, and I know that negotiations are ongoing. Frankly, for a U.S.-EU Cloud Act agreement for purposes of facilitating law enforcement access to data that's located overseas in this case. The only other thing that the EO itself says is that there is there is a process for revoking those designations of as a qualified country if suddenly those criteria are no longer met. I would imagine one of the other things that the executive order does, of course, is that it does state that there needs to be some further implementation of various of the safeguards and other things. I don't know if there's going to be more said on exactly what the process would be in that regard, but it does mean that what other countries' laws are in this regard, in these regards, are relevant, certainly.
And let me add to that the interesting part of this from a European perspective is that those elements of national law in Europe's case will not be found in EU law. They will be found in each of the member states' national security and surveillance laws and practices. So whatever that process looks like, it is likely that it will be applied to each individual European member state. So that's going to be an interesting one. We are about to reach the end of our time. I wanted to address another question, which broadens a little bit the discussion. It's about whether the issuing of this executive order will diminish or stop the sovereignty policies like the Cloud de Confiance in France and the EU-legal negotiations of an equivalent, the European Cloud Security Certification Scheme. So these are initiatives the French one, but most likely, most important, I would say the European cloud certification scheme that introduce requirements that would apply to cloud services in the European Union. The goal is to ensure security of these services, but there is a lot of, I think, concern across the industry. Also, ITI has expressed serious concerns that a number of these requirements actually have less to do with technical security measures and more to do with other political considerations, like, for example, the origin of the entity that is providing the services and whether this entity is based in the European Union or as its ownership can be linked back to the European Union or to a third country. And so, again, to a certain degree, some have described these practices as protectionist or discriminatory. On our part, we're certainly being very concerned with this, and we are expressing this concern with the political counterparts that are looking into this. So the question is, will this change somehow the approach here? I'll let John reply on his own. My answer is, I don't know. I don't see how this necessarily might directly affect these practices.
Yeah, I mean, it's actually a great question. I mean, it's notable, right? I mean, if those sovereignty policies, and whether we call it data sovereignty or even there are policies in other jurisdictions where we sometimes refer to as data localization policies. If those policies were only motivated by concerns over privacy and concerns over government access to personal data, those are kind of the core element, core interests that I think are addressed in the executive order and DOJ regulations, because those were the interests that were raised and the issues raised by the Court of Justice. If that were the case and those were the only interests on the table, then I think I would maybe disagree with Guido, but I'm going to agree with Guido because it's clear that in some of these policies, and if we look at in the EU context, for instance, the Data Act or the Data Governance Act, there are restrictions on cross-border data transfers for non-personal data. So there's no privacy interest or individual right even that's necessarily implicated there. So as Guido said, I mean, it could be cybersecurity, it could be privacy, but there are, arguably other protectionist interests at play. I think, various officials have said, well, it's kind of more like they've acknowledged that there's more an economic dimension to it all. So, I mean, I do think it'll be helpful in, maybe broadening the context of the conversation to really talk about what we're trying to achieve by these policies and, how we kind of, as again, going back to the beginning, how important allies and partners are really going to operate in the global economy, because there's got to be a way that we can work together as opposed to cross purposes on some of these issues.
Thank you, John. I think that's exactly, that reflects exactly that situation here. So we're actually 1 minute over time. So thanks again. Thanks a lot, John, for all of your explanations and going into the details of this. Clearly, this is the beginning of a fairly long debate that will stay with us for several months. So we'll be happy to continue this dialogue, continue organizing eventually these calls at crucial points throughout the process. ITI will certainly be very, very engaged into this process over the coming months. So don't hesitate to reach out. Thanks for being with us. Thanks for all the very interesting questions, and looking forward to be with you all again.
Thanks for me as well, Guido. And as you pointed out, beginning, this is not over by this. There's a lot of hard work to be done still, particularly on the European side, to fully implement this. Thank you.
Have a nice evening. Bye.